meeting.
We need
Go
to
to vote on
vote
the
on
motion
approving the
first, excuse
agenda.
Oh, okay. I thought you wanted to do it before we voted. But Secretary O'Donnell, can you please call for a voice vote?
All those in favor, please say aye.
Aye.
Those opposed, same sign.
Nay.
Okay, that motion passes. At this time, I will turn it over to the College Attorney, Ken Flory, to indicate the purpose of this meeting.
Thank you, Chair Burt. The purpose of today's meeting is to clarify a procedural question that arose during the last meeting on January 22nd at the time that Dr. Bruder's fourth addendum to his employment contract was approved. The board is not here to reconsider the approval of that vote. The board is not here to address other procedural issues that have been raised throughout the week. The board is here to clarify the issue regarding a statement during the debate of calling the question. During the debate, one of the trustees called the question, which is commonly known as a process by which debate is stopped during the motion on the table, and there's immediately a vote to follow. It's very common for a call to question to be misconstrued as you simply utter those words and the debate stops automatically. Under Robert's rules and parliamentary procedures, call the question is actually a motion to stop debate. And if that motion is properly made and properly seconded, that is an intervening motion that should be voted on prior to voting on the main motion. Because of when we reviewed the proceedings of the meeting and this issue was not as clear as we prefer, we could have proceeded forward. The college could have decided that the facts surrounding this question were sufficiently addressed at the board meeting, or they could decide to reconvene the board meeting to clarify the intent of the trustees. And from our review of the tape, the intent seems clear, that the vote of 6-1 was validly taken to approve Dr. Bruder's Fourth Amendment to his employment contract. The comment to call the question and a potential second did not validly occur, but it raised some discrepancies or some confusion about what the intent of the board's vote was. Again, we believe after reviewing all the documents and the recordings and the playback that the board properly voted on approval of the contract. Rather than going through litigation, attorney's fees, time, expense, related to this question and other questions, the college and chair decided to take the high road and readdress this issue.
Just keep going for the record.
To address the issue and reconvene this special board meeting so that there is no doubt and we don't end up discussing before a judge for the next 2 years and an appellate court after that over what the intentions of the board were when they made the vote. Tonight's meeting is solely for the purposes to clarify the board's intention that when the vote was 6-1, it was to approve Dr. Bruder's Fourth Amendment to his employment contract. Additional questions have arisen during the debate that also need clarification. There's a question about whether the severance payment as provided for in Dr. Bruder's Fourth Amendment to his employment contract would result in an increase to the pension benefit that Dr. Bruder receives under Illinois law. This also should be clarified because of some of the statements made during the debate. Dr. Bruder operates under a CSRS self-managed plan. There are two plans under CSRS, State University Retirement Services, a defined benefit and a defined contribution plan. Dr. Bruder is under a self-managed plan, so the severance payment has no effect on his pension payments. It is no way increasing his pension payments. His plan is similar to what we all know as a 401k, where we manage it ourselves. It's not a set benefit, that percentage of the last salary, which many public employees' pensions are based. This is a plan where he directs it, he makes the decisions, and his payments during his pension are solely from that amount of money, again, which will not be increased due to the approval of the Fourth Amendment to the employment contract.
Okay.
And I'd be glad to answer any other questions about the procedural issue I've raised or any of the other comments made during the debate on the approval of Dr. Bruder's Fourth Amendment to his employment contract.
Do any board members have any questions as to the purpose of the meeting? Okay. Seeing and hearing none, I will move on in the